Well, it's a pleasure to be here. I want to thank everyone for the invitation, and specifically Andrea. She came to my office a while back and said, "Can you fill a spot?" So you must have been pretty desperate to be asking me, but I'll do my best to make this as entertaining as I can. Andrea touched on it a little bit here. Let's see if I can, why did Christy shouldn't have left? I don't know why this isn't. There you go. Andrea touched on it. I was actually a juror. It was the first time I'd been selected to even come to jury duty. And so I was kind of surprised that they even let me sit there to be questioned, number one, but it does not disqualify an individual to be a juror by being a seated judge. And I've actually used that to my benefit as a judge now when I introduce a case to prospective jurors and they're all sitting there like, why am I here? And I explained to them that even a judge can be a juror, that I found it to be a really good experience. It was an excellent experience. Actually, I think it's made me a better judge. I know what they go through. I know what they're thinking as they're sitting there through all stages of the trial. And just to give you a bit of a background on the case that I was selected, it was a theft second-degree case. Sat there through the questioning of the process, and I was going to be one of the alternate jurors. I thought, are you kidding? I'm going to sit here as an alternate and not actually get through the process. But one of the jurors had a bit of an anxiety and just could not sit as a juror. So then I filled that spot. You may be thinking, well, how did everybody know that you were a judge? Only the defendant, the attorneys, and the judge. It was discussed prior to jury selection that it would not be disclosed to the other jurors because they did not want my position to influence the other jurors on the panel. And I truly did not want to be the foreperson. I wanted just to be a part of the process. But I think the suit gave it away that first day. Even though that there's other jurors with other previous juror experience, when it came to select the foreman, they all turned to me. I couldn't believe it. And I said, no, I think you should have these more senior gentlemen serve as the foreman. They've done this before. They know how to work with the instructions. Not that I didn't, and they just would not listen. So I was forced to be the foreman on that trial. It was pretty humorous though too, because we had 3 questions as we deliberated, and after the fact, Judge Tabor, who was presiding over the trial, she said, "Couldn't you answer it for them?" But because some of them were just so elementary, and I knew exactly what the response from the judge was, as you all know, reread the instructions. And so it was disclosed at the end. We started talking a little bit more. I was able to hide the whole fact of my position until the very end. After we finally reached a verdict, we started talking about things, and it came out I was a judge. I thought that the jury would have been very upset because we had a bit of heated discussion between ourselves, not too much myself, but between some of the other jurors. And I thought they would have been really upset that we wasted all this time and I could have stepped in to expedite the process. And the jurors were very good about that. They appreciated the fact I did not disclose I was a judge to influence their decision in the case. So they were very appreciative of that. And then, of course, they had a lot of questions then after that. You know, they couldn't believe that I knew the judge, the attorneys, and believe it or not, it was the defendant that really wanted me on the jury. So I thought that was kind of a interesting fact. Yeah. He was found guilty, but it was a lesser degree of theft. And I'll touch on that in just a bit during this presentation as to what happened during that deliberation, because some of what I'm going to talk about I learned during that jury process, and I think you'll find it interesting. Another thing, the best part of my job, I believe, one of the best aspects, is speaking with the jurors after a jury trial. It is fascinating to hear what they have to say about the attorneys, the defendant, the facts. Why didn't they do this? Why did they do that? And I'm pretty free with the information within reason that I can give to them. And when I preside over a trial, I try to be very conscious of the jurors because of my experience sitting there and even handling criminal cases. They hate to sit in that jury room. They just despise it. So if we can minimize their time in that jury room by advising them, we're working on jury instructions, we're working on legal matters that do not need your attention. And I know a lot of the judges are very good about informing them of that, but I'll actually have jurors come late in the day, late in the morning, if we have to work on an issue, so they stay out of that jury room because they really appreciate it. And it does pay off for everybody that is handling that case, prosecution or defense. My goal today is to hopefully gain some insight about jurors and juries themselves. You're going to have to accept how today's technologies are impacting juries. And I see it every time I have a case that is tried. And you may already understand that. I'm just giving you some food for thought as you present a case, what you might want to utilize and think about as you're presenting your case. Jurors are much more demanding of attorneys today. And I think that has a lot to do with technology and the resources that jurors have at their fingertips. And it makes attorneys' jobs harder, I believe, because you have to work within the parameters of the law and what evidence you can present and how do I answer all their questions within those parameters. I think there are ways of doing that, but that is something to be concerned about. Even though I'm going to talk about some negative things about how we have to deal with jurors and juries, for the most part, though, we're very fortunate in the state of Iowa. I can only talk about my district, but I'm pretty sure it's a good cross-section of the entire state. Jurors want to do a good job, and they do listen probably a little bit more than you even think they do, and they view everything that goes on in that courtroom. Juries are changing. Yeah, 12 Angry Men, all men, all white males. That's where it all started, and it's changing. We have a good cross section, hopefully. I know that's kind of a hot topic now with juries. Whether it's a fair representation of the community. Sometimes you might think you have a cast of characters, and yeah, that does happen sometimes. But they are trying to do their best with the evidence that they've been presented in a case. I thought this was pretty good. Yeah, good luck, because people, when they come to jury service that first morning, they're listening to that video before they start being questioned by the attorneys. They're bored already, and I try to be inviting as I can when I introduce a case as a judge. Thank them for being there, and I know a lot of attorneys, when they're starting their questioning, thank them. But when you're starting that questioning and introducing yourself and the case to the jury, you need to find a way to connect almost immediately. That first impression is so important, to draw them in, make them understand that their job is important. You're asking them to do something important here. It'll go a long way by establishing that relationship from the get-go, even before you start the case as in chief. Hopefully you can read some of these comments. It is interesting. individuals, and particularly in a criminal case, often people are finding a way not to serve as a juror. You know, every defendant's guilty. I don't trust the police. All of those thoughts are going through their heads. I try to nip that in the bud when I have a very vocal juror, potential juror. Sometimes, not often, because we have a decline in our civil cases being tried. But if we have a civil case, I'll call that juror out and say, you know what, Ms. Smith, this isn't the case for you. I can understand criminal law just isn't your game, but I'm going to send you down the hall to that civil case that we have. And even if we don't have a civil case, I will call them out and direct them to our juror administrator in the clerk's office and have them come back for a civil case. And I'll have them scheduled to come back for a civil case. Kind of sets the tone. They're not going to get out of not serving, and it is a great experience. What's important during the voir dire process, and you know, some of this might be very repetitive for most of you. You're very experienced criminal attorneys, most of you, but I can't tell you when I sit there during jury selection, and it's very clear that the attorneys haven't even glanced at the jury questionnaires. And it's wasting time, number one. You're losing the opportunity to connect with those jurors. I've seen some really good attorneys, one from the State Public Defender's Office. He memorizes, and it's amazing, the jurors, the potential jurors' names, what they do for a living, if they have children, and he's not even looking at a note. That's the exception. But if you look at those questionnaires, you can see where they're employed most oftentimes. Say, Mr. James, I see that you're employed by Deere & Company. What do you happen to do at Deere & Company? I mean, that's a conversation. That's just not a question. It's an actual conversation you're having with those jurors. And being, you know, defense or prosecution, you're connecting immediately then to that person. They're going to be more willing to answer some tough questions that you might have concerning your case. You know, particularly like a sex abuse case. You know, that's a tough thing to talk about. But if you've made that connection, you've made that conversation initially with those jurors, they're more apt to speak with you about those questions. Take notes. As I said, while you're looking at those questionnaires, take notes about those jurors. And you may not get those, you know, a half hour before, but you have a good, you know, 20 to 30 that you know that you're most likely going to question, highlight, make remarks on those questionnaires. And then during, I can't tell you how many times it's evident the prosecution's asking the question, the defense attorney then asks the same question. And you can see the jurors getting annoyed. They hate it. It's a waste of time, and it's very important. Again, you don't repeat the questions. You can follow up on the responses. You know, it's pretty clear sometimes in a case, an attorney is asking a question of one of the potential jurors, and they don't really follow up on that because they don't want to hear the answer, but the other side wants to hear that answer. Sometimes I don't hear the follow-up, and it's pretty important that that attorney should have followed up on that response. And I get it. Sometimes your client or co-counsel's talking in your ear, but somehow you've got to find a way to take notes during the questioning while the other attorney is asking questions. And as I said, it's just ever important to make that connection with the jurors. Social media, it's there, it's staying, it's gonna be around for a long time, and I see it impacting our jurors. And I've talked with some other attorneys in my district. It's that instant gratification that you get from social media. You know, I love technology. So I'm probably one of the few judges. I have Facebook, I have Twitter, I have Instagram. It's more to make sure to see what my kids are posting on Instagram or Twitter, tweeting, or what they're following. I don't post on Facebook. I just am a stalker of my friends, and all their cute kids pictures and all those positive things. I don't respond to anything politically. I'll put that out there as I can under my judicial ethics. But it's really important to understand those technologies because they're influencing our jurors. They sign up for instant notifications for their news, whether it be CNN, their local newspaper, if it's available. They're receiving those notifications from those sources. So they're used to that. It's right there. It's being fed to them all the time. Or if they're hitting, if they're on Twitter, they're seeing their tweets from their favorite individuals coming in, posting, following them, getting all that instant information. Instagram, they're following individuals that they like to know what's going on in their life. They're looking at that information. If it's a person that they follow all the time, that person's posting all the time, so it's instant. And then Facebook also, just instant information. So as I talk about this, is they're receiving that instant information during your case. If you're comfortable with technology, use it. And if you're not, start going to some classes or go to some seminars of how you can implement it in your case. Because we're all guilty of it. I see all of you with smartphones, your iPads, your computers. So the jurors are becoming more sophisticated also. They have that technology at their fingertips. So in the presentation of your case, they're comfortable with that technology, utilize it, because it's something that they see in their daily life. It'll make them more comfortable with the information that's being presented to them in the case. Now we'll go to that instant gratification a little bit more. I've said this also before. Siri can give us an answer. All we have to do is pick up the phone and say, "Hey Siri." We can do the same with Alexa. We can do the same with Google Home. But why can't those darn attorneys during the case give us that instant answer that we want? I have found that, and I think it is a lot to do with that technology that everybody's using, that they can just ask, questions. And as I bring up questions, I forgot to say at the beginning, raise your hand at any point if you want to ask me something. That doesn't bother me to be interrupted. So that fact that they can get that instant information, they want to be spoon-fed by the attorneys presenting the case. It's very clear when I talk to jurors. And so when you're presenting that case, you have to do your best to make the evidence presented as clear as possible. And if there's limitations as to why you can't present some evidence to make that connection, such as, the prosecutors are getting a little bit better as far as, not every case has fingerprints. They just don't have the resources. And sometimes fingerprints aren't that readily accessible. It's not CSI. Attorneys are doing a little bit, they hit that, during voir dire, watching TV, and we can't get a case done in an hour. Even given that, I've had a case on both sides where they talked about bedrooms in this specific case upstairs in a house where a sex abuse had occurred. And they talked about where the positions of the rooms were, but no one ever presented a diagram of the house or pictures of the room or something of that kind. Drove the jurors absolutely crazy, because there's a question of whether there was someone in another room could have seen in or had access to that room, and just talking about it was not enough. So it really created some doubt and some big questions in the jurors' minds. And I did fault the prosecution in that case because it could have been easy for the detectives in that case when they did the search warrant or on the arrest to take pictures while they were there. So I'll share some of that information with the attorneys after the case if they would come and talk with me to share some of those concerns of the jurors. But I think that's the biggest thing. They just don't think that the attorneys, or believe that the attorneys or the police take enough initiative to give them all the information that they need. And I think it's very important to make that connection as you're giving the testimony, and don't leave any unanswered questions as much as you can for the jury to decide, but for that ultimate question of guilt or innocence. I thought this was a good thing to think about as you're getting ready for a case. If you can't explain it simply, you must not fully understand it, because they need it simple for the jury. You need to break it down to each and every element. And think about, if you're a prosecution attorney, think about the elements. If you're a defense, think about that defense that you're trying to present. Hit the elements of that. This is something that's very concerning to me, and it was a concern for me when I served as a juror. The whole sense of, we tell the jurors to use their common sense in reaching a verdict in a case. I feel sometimes they just throw it out the window, but I don't think it's completely dead yet, okay? What was concerning to me in my case was a theft second degree. The facts were really fascinating. This gentleman went into a quick shop, and he didn't think it was so convenient just to hold it up. He thought he'd just take the whole register with the money and the checks and everything like that, and ran off with it. And so, as you know, one of the elements is the value of what was taken. In that case, the prosecution they caught him, of course, and they had pictures of all the money that was in the register, fanned out. So as a jury, you could count all of it, the checks that were there front and back, and then the register itself. They had an employee of the quick shop testify as to what the value of that register was. And they had a picture of an employee with like a sign saying that's how much the register was worth. That was part of the evidence. And we really only had to find that register, in addition to the cash and the checks, was worth about maybe $500 to $600 to reach that threshold of theft second degree. And some of the jurors just didn't feel that evidence was sufficient to show that was the cost of the register. And some of us, and I was one of them, said, well, let's use our common sense here. I said, I have children that go to school that get issued Chromebooks. They're about $300. They're basically disposable computers. We know that this register is worth many hundreds of dollars or more than that, because it connects to a satellite, with their corporate, all of that. No, prosecution didn't do enough. Why didn't they have an invoice? Why didn't they have it? Those are pretty good questions, but common sense would say it's worth them more than $500, but they just would not go there. So then we just worked through it and went through the different levels of theft and got to the amount that all of us could agree upon. So that's why the individual was only found guilty of theft third degree. So it may be very simple to us. It's common sense. Come on, you know what that means. And we have the jury instruction that talks about it. But I can't tell you, you've got to talk and talk and talk about it. Possibly talk about it during your opening statement if you know that's a potential issue or consideration they may have to consider during your opening statement, during the closing statement, and actually refer to this jury instruction when you're doing your closing. Yes? It was. No, not that I could recall. Yeah. 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 Now that they're aware that they can use their common sense, you have to educate that jury. Take that opportunity during your voir dire, your questioning of the jury, meaning talk about the facts of the case, talk about some of the issues that are going to be presented. Put that all out there, educate them before the case is even presented. During direct and cross-examination, make sure that you look at those jury instructions. That's a good tool. Make sure what has to be proven. If you're defending the defendant, point out during your examination what isn't being proven during the testimony. And that closing argument, I think it's most effective. I see a lot of closing arguments that are getting much better with the use of technology and PowerPoint. It is an excellent tool. Walk them through the jury instructions. You know, the judges read them, but we're reading them as fast as we can so they can get into the jury room. We're not really explaining it to them. It really needs to be done during that closing argument. Make sure you walk them through it. Tell them exactly what you want at the end. Don't leave it up to chance. Don't leave it up to that common sense. Tell them what you want. Yes?
One of my pet peeves, I think, is with regard to closing arguments. You know, prosecution goes first, defense counsel goes second, prosecution gets to get up again. The idea behind that last shot is just to cover those things that the defense counsel brought up that they weren't able to cover the first time. Invariably, they will go through their whole case a second time. And anytime I've objected, it falls on deaf ears.
That's really rebuttal. That's interesting. I've never had any prosecutor do that so far in a case that I've had. They may touch on it a little bit, but they're not regurgitating. I think that's really poor on the prosecution, in my opinion, because it's just going to annoy the jury. They've heard it before. They don't need to hear it again. I hear that a lot. They don't like things being repeated. I don't know how to answer that. Yeah. Let the jury get bored and annoyed because they will hold it against an attorney. That's for sure. That's for sure. Yes. Yes.
Leaving the facts into voir dire and the objections just start flowing. That's argument. He's not talking about the appropriate reasons for voir dire. So I'm wondering when you go to these judges meetings, because there's such a wide range of response. And
right.
I suppose if you look at the technical aspects of voir dire, trying to look into these people's backgrounds, etc., but not the facts.
Right.
Now, put back to the use of electronics. Do you have any problem with demonstrative evidence in voir dire, where you actually use things as part of your voir dire? Because there's an increasing willingness to allow you to refer to expected jury instructions. And so I'm wondering how far we're going to go with this, because I've seen people constrained. So what's your thought?
I think you'd have to be really careful. I think it'd have to be, if you're going to do that, I'd maybe have pretrial motions talk about that so that you don't have any issues before the jury. What type of demonstrative exhibits have you used?
One of the simplest ones is the stair step.
Okay.
Take them up, you know, to beyond a reasonable doubt.
Sure.
I've had one judge say, "Oh, that's argument." Really? I thought we were allowed to talk about that.
Yeah, that
one stopped me.
interesting.
But that's what I'm getting at. Is
Okay.
we increasingly go to electronic viewing of various aspects, evidence or examples of argument. What are your thoughts on that?
Well, I don't want to overrule one of my colleagues, but I probably would have allowed that one. I think that's important. I mean, that's what you're there for, to see if they have a trouble with that concept of beyond reasonable doubt. So I think that's very good exhibit. And I think that's good for both sides, in my opinion, as you're questioning those jurors. That would not bother me. And I think, some of the judiciary are there's a tide, I think, in my opinion. I'm a young judge, so maybe I'm speaking out of turn, but I think our judiciary is going to have to realize the impact that some of the social media that I talked about earlier, how that's impacting our cases, not only in the criminal realm, but really in the family law realm also. So, and I just think the use of video and those types of things, it's going to be necessary in trials, and you're just going to see more and more of it. You see a lot of attorneys not even using laptops. They're starting to use, just the iPads and such, and using all that technology to throw things up on a screen. So, no.
Jurors, but it does have to do with affecting jurors. You see situations where, for whatever reason, you make an objection and the judge appears to be a little more solicitous on one side than the other. Instead of ruling on it and saying sustained, why don't you try it? Or that type of thing. And I see this with sidebars too. Jurors watch sidebars really closely.
That's right.
What are your thoughts on ruling where you basically subtly advise the attorney, just at the objection against them, to try a different approach as opposed to simply sustain the rule?
My typical process is to usually just rule. Now, if there are continuous objections, and maybe it's a less experienced attorney, I may say, you may want to move on or find a different way of asking that question. I think the other attorney understands somehow, some way it's going to come in, most likely because they know what evidence will be allowed. But it's a proper objection, so it has to be sustained. I try not to do that, but I know it happens.
Tying that though to your sitting, for example, they must have commented on how the judge conducted themselves and whether or not they were neutral. Did that come up in your
You mean when I was on the jury panel?
Now you're on the other side.
Yeah.
You sat in the very spot the judge is in. You watched how the judge conducted the responses, the colloquies, that type of thing. What was your impression about how closely they watched the judge for guidance in terms of?
Oh, they do. They do. They definitely follow what's going on.
Final thing I'd ask them is those sidebars. I've often wondered, the sidebar, you don't get much of a record because we're sitting there and sometimes they don't even take it down. But the point is, what insight can you give from the other side about how silent sidebars are viewed as opposed to stepping into the chambers and just making a record?
The sidebars, I'll touch on that. Early on in my career, I had a pretty tough defense attorney, and it was my second trial that I handled, a criminal trial as a judge. And we had a discussion after, on a break, and we were talking about one of the sidebars. And he made a comment that made me uncomfortable, that he felt I was being unfair. So from that point forward, and I've done this in any case that I have, I will make notes on the sidebar that we had, the bench conference, and on a break before then the attorneys and the clients leave the courtroom, I make a record of every bench conference I have. And it's a good record then, I feel, and I've heard and not just my case, appellate judges that like that, because that record shows absolutely nothing about that bench conference. They can probably glean from the official record what was talked about, but they don't know for sure. So at that time, I always summarize those bench conferences and ask the attorneys then if they agree or disagree with my summation so that there's a record as to what was talked about. So I'll just pass that along to you, that if that's not a practice of some of the judges in your district, I don't see that there's a problem if you want to make a record of that, so you have that good record of what transpired during that bench conference. And it's probably really important for the attorneys to have that record for the appellate purpose, so that at least you can say, this is the reason I made the objection, or what was trying to be introduced as far as evidence. So I don't know if that helps your answer.
Well, it helps because you're making repetitive objections on a very, very important point. You're basically having a jury going up and down like a pogo stick.
Right.
So the idea of the sidebar is we'll try to resolve this without making them go in and out, in and out, in and out.
That's exactly right.
But if your recommendation would be, and I think logical, you want to take that up because the point is the ruling has to be made then.
Right.
So that's the difficulty you have irritating the jury, persisting in what's a very important point.
Right. How am I doing on time, Christy? Okay. Well, I don't have that much more, but go ahead.
Thank you, Your Honor. In addition to what you stated about jurors' comments about not explaining enough, additional counsel is noted. What else in your discussions with jurors has the jurors seem to be upset with attorneys for doing or conducting, and how they conducted the trial, or et cetera?
The question, the voir dire, that is, I'll touch on that first. That is probably the most boring aspect of a trial for them. And as I said earlier, that repetitive questioning, and I know you have to ask the question of each and every individual juror sometimes, but not listening to their responses and then asking the same question again, or if they feel that some of the questioning of them to select them has really nothing to do with the case, sometimes it doesn't, to be quite honest. That is just the biggest annoyance to them, because it's really boring. I mean, you're sitting there while they're talking to these other individuals. So number one, that's been the biggest complaint that I've heard, why that takes so long. And particularly, I'm not trying to minimize any type of criminal case. If it's a murder case or a sex abuse case, those are very difficult cases to select jurors. But if it's a criminal mischief or a theft case, or pretty simple facts, jurors are sophisticated enough. They're thinking, why did this take so long? Sometimes I see the other side. If one attorney is asking so many repetitive questions, or just off the point, or they're not making any inroads with the jury, the other attorney will take advantage of that and ask less and say, oh, I think you're all great jurors, I don't need to ask that many questions, and turn it. And I've seen it, and it works. I'm telling you, the jurors pick up on that. I would also say, they do not like, again, even during direct and cross-examination, the repetitive nature of it. If there's not a real good point to be made, avoid it at all costs. A lot of us move very quickly because of technology, and they expect a trial to move as quickly, as efficiently as it can too. I don't know if that answers everything that you were concerned about. Okay. And that goes into this next slide. And I did add this separate from the materials. I did just this one extra slide. They observe everything. The eye rolls, when you're just exasperated with the other side, it makes no points with the jury. I'm just letting you know. I had a very contentious, and this isn't a criminal case, but it'll apply to a criminal case. I had a very contentious civil trial. Very good attorneys. The one attorney, very esteemed litigator. He had every reason to be upset with the other side as to how they were conducting the trial. But the jury, and he won basically the case. But even though he won, the jury made it a point to tell me, you know, you really need to tell him to stop throwing his pen down and leaning back in his chair, looking bored with the other side. We did not like that. And it was an honest feedback because they really liked him, but for that. And they thought that they knew he was a good attorney and they wanted him to be that attorney and not have that take away from what his abilities were. I hear probably more about attorneys being unprepared or appear to be unprepared. That's a big distraction for them. They see that. So they do watch. They watch the defendant during the case to see what their facial expressions are during testimony given, whether they're interested in the case. You know, this may not, and it doesn't ultimately make their final determination in a case, but if the defendant testifies, you know, that goes to the credibility as to their interest in the case and what they're doing. Others are testifying, so you might want to have that discussion with your client as to, you know, how they're conducting themselves during the trial. The witnesses, you know, sometimes the witnesses will, after they're done testifying, if they're allowed to come back in the courtroom, they see them in the gallery. They see what they're doing. So if you have concerns about what they might be doing in the gallery, have that discussion with your client's friends or family that are testifying. And they look at the gallery. They will see if there's family members there, what those family members are doing. I just had a criminal case that it was a murder case. We had concerns about the family, what they were going to be doing during the trial. We had a heads up on that. And there was some whispering, there were some statements being made. So we had to really watch that. I don't think it ultimately caused any concern as the final decision by the jury. But it was a concern that they had for their safety. I think with the climate today in our society, I think jurors are ever more concerned about their safety. We have recently, and I don't know about other districts, but if a jury is polled, we had a lot of discussion about this. We don't say their names anymore. We just say jurors 1 through 12, even though that may not be their juror number. And I believe that's a sufficient record so that you have 12 people saying yes or no. I had a very innocuous case. I think it was just like a simple, not any real bad assault case, but the gentlemen on the jury were more concerned about their safety than some of the women. I was shocked. And this was during the transition of what we were going to do about polling the jury. And we did not use the numbers in that case, but that case made it, for me anyway, that's how I do every case now, because they were very concerned, and particularly in this murder case, because of what was going on with the people in the gallery. We did do that. And I've tried to talk to some of our Supreme Court to look at some of the rules. If we could do something different than using names during jury selection, because that is one of the comments I get all of the time, the information that's being shared with the defendant. I try to assure them that those questionnaires are destroyed immediately after they're selected. And I assure them that you could see there's no notes being taken by the defendant or anybody else about your names and addresses. And that usually works with most of the jury. And they, as we talked about, they look at the judge while the case is being tried. But that might be some of the negative stuff I've talked about, but as I said earlier, we're very lucky. Most jurors take their oath very seriously. And I know this because I had a very high profile case early on in my career. It gleamed national attention and was being covered by national, USA Today had an article on the case. It was being blogged on. I was receiving emails from across the nation and phone calls. And so we were really concerned about the publicity that that case had. And I've talked to, and particularly in that case, they knew there's cameras in the courtroom, so they knew it was being covered. One of the jurors actually had her husband, she shared this with me after the case was tried. He cut out all the articles from the local newspaper that had the coverage of the case because she took that oath, and all of them, even the news coverage, they did not listen to the news that week and a half that the case was being tried. Every single one of them confirmed that. They said, no, we did not. We didn't let our friends or our family talk about this case, even though they knew it was a pretty hot case that was being discussed. And they worked really hard to reach that verdict. When I've talked with the jurors after a case is tried, they speak about going through the jury instructions. And even in my case, when I was one of the jurors, we were working through those jury instructions and rereading them and trying to make the connections, spreading them out, maybe jumping from this jury instruction to the next. So they do work hard. And they discuss how the facts can be applied to the instructions. And the bottom line, every time at the very end of my discussion with the jury, did we get it right, Judge? Okay, they want to know if they got it right. My answer is, regardless of what I think, of course you did, because that's our process. All right, they need that affirmation that they did the right thing. So the bottom line, it's not all bad. I just think as practitioners, we have to consider how we can be more effective in the presentation of our evidence. Whether that's using more technology, I think that's the first and foremost. I think that has a big impact upon our juries today. And just think about as I said earlier, just think about how you can connect more effectively with the jury as you present your case. And how can I make that necessary evidence that much easier for the jury to understand? That's really important. And I might be a little early, but I thought this was a great way to end the slide, the presentation. Yeah, reasonable doubt, confusing jurors since 1657. So I thank you. Are there any questions at this time? Because I know I'm a little early. Yes.
So when you rule on motions to strike, do you take into account jurors' nonverbal cues as opposed to what they're just saying? Because many times they all want to say they can be fair and impartial, but you can tell by their body language they can't be. Or they use certain words that indicate a racial bias or something like that. Mm-hmm. And again, nobody's going to raise their hand and say, I'm a racist.
Right. I think that's a really good question, though. And that brings up a really good point. You shouldn't be afraid to talk about it. I know it's the big elephant in the room, but if you have a black defendant and you have an all-white jury, start talking about it. That's what we're there about. And I actually saw an attorney bring that up and just speak about it, just very, very honestly. Don't you think my client feels very uncomfortable here? And it really started a discussion. And I wouldn't be afraid of that. It's out there. Everybody's discussing it. So it's not like something new. But as far as the body language, I think that's up to the attorneys to decide if they're just not comfortable with that juror.
Right, but it's a motion to strike, so you have to decide. Like in a sexual assault case, if the juror is crying when she's saying she committed impartial, to me, that's pretty good clue she can't be.
Right. But generally, and I will say though, I've had that happen, but then the attorney says, Your Honor, for the record, I just want it to reflect that this individual can't even answer the question, and they're crying or have tears, or they're welling up with tears. And then I've done that. I've confirmed. And I will say I agree, and it's very clear that this person's very uncomfortable, has the inability to make a decision in this case and grant it. Yes. Yes. Yes.
Did having to apply jury instructions as a juror change your perspective of jury instructions at all?
A bit. Yes. That's a good question. They're hard. They're really hard. I mean, I have the legal basis to kind of basically work through them, but trying to take every single individual instruction and make it one document to work with to make an ultimate decision is a difficult thing. And so that's why I think it's very effective during that closing argument to walk them through the jury instruction, what you ultimately want them to reach a decision on using those instructions, because we're just reading them to them and handing them to them. The closing argument is where both sides have the opportunity to point out, if you're working the defense, this is what the prosecution has to prove, but they haven't proven this element, and this is why. And so as you work through this instruction, it says, if the state has not proved this element beyond a reasonable doubt, you must find the defendant not guilty or, a lesser included offense. Walk them through that. It's really important. I think it was pretty effective in the murder case I had. He was found guilty of second degree. It's still a very serious sentence he's facing, but at least it's not life. And I think the defense made a good argument by using the instructions on each and every element to hopefully get a verdict of a lesser included offense. They understood. I mean, this individual was shot 5 times. It was a pretty tough case. They had to make an argument for a lesser included. So
based on that experience, have you done anything to modify your instructions?
I try to encourage the attorneys. I maybe put them I like my definitions, and I don't like to, I always have the adage that it's the attorney's case, all right? Ultimately, I have to control it, but I like my definitions together so that it's it's easier for the jury to go to this section, the instructions, to refer back so that all their definitions are together. Some attorneys, and I see it both ways, but like in my murder case, they didn't like that. They wanted each definition behind some of the instructions. But that definition relates sometimes to other instructions, so that's why I don't care for that. But I have organized my instructions a bit differently in that respect. Yes?
I just had a comment. I also served on a jury about 4 years ago. And one of the things that I hadn't thought of before, that I think, I don't do jury trials, but all of the attorneys who do jury trials, we had a couple of people who were chain smokers on the jury. And in this particular case, Judge Pilley was not allowing us to go outside for breaks. And so we were just going to places in the courthouse for our break. And I know that judges make different decisions about that issue, but by kind of midway through the afternoon and our first day of deliberations, they were pretty much jumping out of their skin, and they were not able to concentrate. We weren't able to do effective deliberations for probably the second half of that afternoon. The next day they came back, they had Nicorette and patches and stuff like that. But
they improvised.
Yes, that had never occurred to me, and I tell my friends who do jury trials that's something to think about, because they were completely distracted, and I think ultimately that can interfere. So I just wanted to throw that in there.
No, you're right. I've had some jury panels that there were a few smokers, in that case, then the clerk, then court attendant, came up to me and said, "Judge, so," but then I made the whole panel go out there with them. They had to stay together, and so it was a nice little march outside the courthouse. But I did that because I just knew it would be a distraction if we didn't allow that. So.
How do you feel about special interrogatories? I never see them. There are some, take an OWI case where there are different ways of proving it.
Yes.
But if you had a special interrogatory that went to one of the ways, it would narrow the question, focus on the question, and narrow the theories. But every time I ever suggest interrogatories for specific factual determinations, everybody looks at you like, what?
No,
How would you?
I don't object to those, and I've had some cases with those, with the special interrogatory, and that doesn't trouble me. I mean, you're trying to help the jury reach that ultimate decision. Now, hopefully there's an agreement between the attorneys, and I've never had a disagreement. Maybe on how it was written, and then we just worked through it, but there was always an agreement that there needed to be a special interrogatory on this particular issue. But we worked through the wording of it. Yes.
Judge, what has been your experience with how juries view a level of aggressiveness between a prosecutor who gets to say, "And then what happened?" with friendly cops, compared to a defense attorney who's then saying, "Well, you didn't do your job, you didn't do this, you didn't do that," and having to cross? And what advice would you give for defense counsel, especially for women who are concerned about how the jury views their level of aggressiveness compared to men?
It's unfortunate, and Andrew and I have talked about this before. It's still something we're dealing with today. And I think sometimes if you feel you've had to be more assertive, I'm not even going to say aggressive, in the defense of your client and you're a female, don't outright apologize, but maybe maybe a good point is to put it out there, even when you're questioning the jury. Are you going to have a problem if I have to ask some really tough questions of witnesses on the stand? Are you going to have a problem that, I'm a female and I'm being really assertive here? Feel them out, because I think that's a legitimate concern. Maybe if there is, and no offense, gentlemen, it's the gentleman you're going to have to talk to. I have had some jurors say that, and I always tell them, you don't understand. They have to present their case, and sometimes you're dealing with a witness that's just refusing to answer the question that's being asked of them, and there's a point that attorney, regardless if they're a female, is trying to make in defense of that client. But that would be my suggestion. Don't be afraid to ask them about it if you know it's going to happen. Anything else? Well, hopefully I haven't bored you too much this last hour. I tried to make it as light as I could. And again, I appreciate it. Have a good night.